very small issue is involved in this matter. If a lordship would see the previous order sheet, the maintainability of the writ appeal is involved, because the petition was filed against an order of the family court under Article 227. Now that petition, which was filed by the grandfather of the child, was allowed, against which this writ appeal has been filed. So this writ appeal would not be maintainable because petition was under Article 227. But if a lordship would see, it was argued at length on the previous date of hearing also. But the father had filed an application for intervention, that was allowed.
Oh, this is, I think there were two cases.
Yes. Lord, if a lordship would see, we can just show a lordship the video in the manner in which the child was taken up. It's a video which was recorded.
Before my learned senior shows that video, I have filed an application for deletion of the name of respondent number 7. That is,
we have no objection.
She's been made a formal party in this case because she was a party in writ petition as well. That's why she has been made. Now she has been implicated as an appellant in the case.
Just give me.
Right, few minutes.
What had happened, just a background. What the co-brother of the boys of the Nitin Dubey, the father of the child, is an IAS officer. The family court directed the custody of the child. The SDO implemented the order. How the SDO cannot be implementing agency, and therefore we have made him a party by name.
Right now I recall.
Yes.
They went to the SDO to prevent the execution of the order
Yes.
passed by the family court.
Yes.
And the SDO allowed it.
SDO went to the house of the child along with the police person. They snatched him from the custody of the grandparents and handed over the custody to the maternal grandparents.
Is that person holding the child the SDO?
No. He is the mama of the child.
The mama. Now the father, I am the father. I am taking the custody of my child.
The earlier video is where the entire police squad is there, my lord. The child has been put to such trauma, my lord.
Just
now on every
your application is IA number?
Minutes 16449. Minutes, I don't think so. It might be uploaded right now. But IA is there.
That is for
application for deletion of respondent number 7.
We
That is Maya Thapak.
We have no objection.
16447.
16449.
2025.
Right.
It's very clear. Heard on IA number 16449 of 2025, which has been filed by the respondent number 7, seeking his deletion.
I am for the appellant because she has been substituted as Ella's and she's been appellant right now. Substitution of Ella's application we have moved last time, and last time my lords have allowed that application, and she's been right. From respondent number 7, she has become an appellant because she has been made formal party in the case because the formal party was there. That's why.
Deletion of the respondent number 7 has been moved for the deletion of the respondent number 7, whose application for impleadment was allowed and has now become an appellant.
Right. Transpose kar diya.
Transpose.
Right.
Under the
Transpose the appellant. Because the maternal grandfather has died during the pendency of this letter. Therefore, the maternal grandmother has been transposed. That is
under the circumstances, the application is allowed. The office is requested to delete the name of the respondent number 7 from the array of parties.
Lord, in fact, the child has become the ego clash of the battle.
In most of about 80 to 90% of these cases, the child is always the pawn. What we call as a pawn in the entire.
That is the form.
This is the manner in which they have snatched.
This is the manner in which they have snatched the child. This was the manner of snatching the child.
Pressure of the IS.
Under the pressure of an IS officer. Now the SDO would become an implementing agency of the order of the family court.
No, just a moment. The family court gave the custody to the father.
The family court gave the custody to the maternal grandparents.
Maternal grandparents.
Nana and Nani.
You are the Nana and Nani.
Nana and Nani.
I am for Nana and Nani.
I am representing Dada, Dadi and father of the child. I am representing Dada, Dadi and father.
So you are aggrieved by the order of the family court.
I challenged it before the High Court. Okay. Petition was allowed, which was under 220. That was allowable. And we filed a petition under 227 and order of the SDO under Article 226 law. That was a consequential one.
All right. So you filed your
Yes.
27 order
27.
against the order of the
Yes, that was allowed.
family court. That
Yes,
is allowed.
That was allowed.
And the direction, what was the direction of the
The custody be given to the paternal grandparents,
paternal
paternal and the father.
Dada Dadi?
That was quashed. The order of the family court was quashed, so naturally, the custody would come to us. That was quashed.
All right. So the child was with you at that time? No, it was with the maternal.
It was with, at the time when the family court passed an order, the custody was with us. SDO snatched the custody under the garb of implementing that order and immediately gave it to the paternal grandparents.
And now
Before the
that
High Court
order is quashed.
Quashed both
By
the orders.
Both the orders by the family court.
Family court.
So therefore the custody ought to be returned to you.
Returned to us.
Right now the child has been abducted. It's a case
With the maternal grandparents.
It is a case, no, maternal, yeah, because now it's a case of kidnapping.
Kidnapping. Now it would become a case. अभी यहाँ से status quo order हो गया है. Writ appeal. There's an order of status quo in this writ appeal. So the custody has to come to us. Now I am the father. At that time I was in jail. I was released or I have been.
Your clients are standing in the position of getting an FIR registered against you for kidnapping. Because that order of the trial court, the family court is gone. That's been effaced. So now they are the rightful custodians of the child, the paternal grandparents. If it is not handed over to them, it would result in the registration of an FIR for, say, kidnapping.
Rightfully, if I may.
It's another issue. Had the mother, the custody been with the mother, being a natural guardian, it's not possible. But the same protection is not there to the maternal grandparents or other family members of the mother's side without an order of a court granting them that custody. So now that the order passed by the family court is gone, it's been effaced, you are now in a very risky situation. Your clients. You can ask them, because others, once we hear this matter, we may be inclined to direct the police to register the case for kidnapping against these people.
It's for that instance, if I may, I seek for passable because my learned senior has to.
All right, then give it a list. What's the short?
He has to address for the maintainability of the petition as well as on the custody of the
I
child.
should bring the child and give the custody to us in the court itself.
Bring the child to the court, and we'll ask your clients to bring the child here at 2:30. Otherwise, tell them we may be inclined to pass orders to register an offense of kidnapping against them. That is, if once we we will of course go through the order passed by the learned single bench. If the effect of that order makes them the rightful guardians, because the custody of the child was with them before the order was passed by the family court. Am I right?
Yes, exactly.
It was only after the family court order was passed, they put an application for execution of that order.
Yes,
Before the SDM.
Under section 100 CRP.
What we would have done was, at that time, we would have filed for contempt of the family court's order. That was an option open to you against them. That is, even after the family court passed that order, they have not complied with it, but you didn't do that. You resorted to something else. Okay, till here also fine, because till that date when the child was taken away, the order of the family court was there. But now that the order of the family court has been set aside, your clients are in a problem. They are in a major problem. Just tell them.
Well, for that, on a let's my learned senior.
We'll pass it over. And
Much obliged.
Try to, these are family matters, try to harmoniously.
Yes.
You see, the problem is, it's a ego hazard.
The child, give us the custody, the retribution would come to an end.
That is all there is.
Father, how I can be deprived of the custody of my own child?
Yeah, you can't. Have you filed an application, this habeas corpus petition also? Now that the order passed by the learned family court has been quashed, you can file for habeas corpus if you want.
Because there is an order of status quo by this court.
Status quo in this case. In this case, you get that status quo so that
you can file an habeas corpus.
File and habeas corpus, both these matters can be heard together. That's the other option.
We have moved an application in this case. But we have moved an IA in this petition, in this appeal only.
For vacation.
For vacating stay and for handing over custody.
Custody to us.
We'll look into that also.
Yes, but that has got IA numbers 6692.
We'll do that.
Yes.
We'll see that, yeah, 15.
Much obliged.
I-1 order next जो भी है सर अभी जो I-1 इससे order
और हाँ ये तो रहेगा पर डेट मत देना इसको अपन दोपहर को ऐड कर दीजिए ये जरा वापस सर yes
item number 11